All right. Good morning, ladies and gentlemen. Thank you all for being here. We got standing room only. This time I'd like to call on Vice Chair Reeves for an invocation.
Let us pray. Dear Lord, we thank you for the wise old owl who lived in an oak. The more he listened, the less he spoke. The less he spoke, the more he heard. Help us to be more like that bird. In your name we pray, amen.
Amen. I like that. That was good. All right. Okay. First bill I'm going to call is not on your agenda. It's Senate Bill 10. And I'll call on Trey Kelly to explain the vehicle.
Thank you, Mr. Chairman. I don't know how I follow that prayer, but I do appreciate everybody showing up today for my legislation. Today I bring before you LC 481605S. Mr. Chairman, it does two things. One, Section 1 of the bill encompasses House Bill 199 that we have previously passed through this body. Passed through House Judiciary unanimously, the floor unanimously, and through Senate Judiciary unanimously, and just ran into a little bit of a roadblock over in the Senate. So that's Section 1. Section 2 deals with an issue of judicial efficiency, where we're given judicial circuits with over 15 judges in the Superior Court an ability to have their own judicial officers should the county decide that they want to work with them to appoint those and to pay for them. Pretty simple, Mr. Chairman. I know we got a lot of work to do. I know there's people here that are able to speak if necessary, but that's the bill, and I'd ask for this committee's favorable consideration.
All right. Any questions by the committee? Representative Oliver.
Thank you, Mr. Chairman. Has the portion in relation to judicial officers been a part of any other bill we've considered?
We dropped it a little later in session, and this committee was working on a few other things, and so we didn't have an opportunity to hear it here, but it was assigned to this committee. We just didn't have an opportunity to hear it before.
So it hadn't had any discussion in this august group. I'm familiar with judicial officers in Fulton County for family law. Is that the concept you're mainly thinking of? And though they are appointed by Superior Court judges and have an enormous amount of Superior Court authority in Fulton.
Have had a lot of success there in family court, and I think you know how much they can improve the efficiency in terms of hearing some of these original motions and things like.
I agree. They've been enormously helpful with some mixtures, of course.
And so they would be used for the
what counties really want this?
Fulton County. It's limited to 15 circuits with more than 15 Superior Court judges, be Fulton County.
Thank you, Mr. Chairman.
Okay. All right. Who's 17 down there?
Representative Kelly may have just answered my question. How many circuits have more than, it's just one? Okay, thanks.
Okay. All right. Any other questions? Do I hear a motion?
Your pass.
Second.
All right. Any further discussion? All those in favor say aye.
Aye.
Any opposed? All right. It passes. Okay. On to Senate Bill 245. We had a late substitute. It was just passed out for you on this bill. So, Senator Hodges.
Thank you, Mr. Chairman. Senate Bill 245, as I presented earlier to the committee, basically is an attempt to establish some additional visitation rights for grandparents. Grandparents who have visitation rights that are granted by court under current law do not have the ability to go back to court to modify those rights for any particular reason. We had a robust discussion in this committee earlier about my attempt to do that. And subsequent to that, I've had some discussions with several of you folks, and particularly Representative Hong, about the primacy of parental rights over grandparent rights, which led to a sub, which you have with you. I don't think I've got the 57079S, I believe.
Oh,
That
I have 570279S. Is that
That's right.
Okay.
Okay.
All right. We're
and basically what that sub does,
Chairman, can we see which sub number LC number we're working off of? Which LC? I just want to make sure I'm looking at the right one.
no, wait, a minute, on the sub.
Yeah, the one that was handed out is the one that we're going.
Did you get the sub?
Can you state the LC number just to make sure that we know which one?
LC 570279S.
That's not what.
That's not what you weren't here when that passed.
All right, thank you.
Yeah.
And this sub is an attempt, after discussions with Representative Hong, basically what it does is it takes, in line 38 of the bill that I submitted, it takes out grandparents. So the basic effect of that is that a grandparent who has visitation rights can only ask that those rights, can only petition the court to have those rights changed if there has been a death, an incapacitation, or an incarceration of a parent. That's basically what it does. And the attempt there is to try to make sure that we establish or continue to have primacy of parental rights over grandparent rights, but it gives the grandparents the right, the law allows the grandparents, if a parent dies, to get visitation rights. But what this does is allows them to go to court and try to have those rights changed. It also allows a parent to try to have those rights revoked. But you go in front of a judge, you make your case, the judge makes the decision, and this does not change the criteria that the judge uses to make that decision. The only thing this does now is give the grandparent who has established visitation rights the opportunity to go to court to have those rights changed if a parent has died, been incapacitated, or incarcerated.
Okay. Any questions by the committee? Who's three?
Sorry, I'm through, yeah.
Go ahead.
Thank you, Senator. So if I understand the new version we're talking about, we've narrowed the population of grandparents who can petition for modification somewhat. In your
Absolutely.
original version, any grandparent who had already gone before a court, proven by clear and convincing evidence that the grandchild would be harmed, could have petitioned for modification.
That's right, Representative.
And now we've narrowed that pool even further so that it's just grandparents who have gotten previous visitation rights and their circumstances are death, incapacity, incarceration.
Of a parent.
Yes.
Right, correct.
Okay, thank you.
I think the previous version, if there'd been a divorce and the surviving spouse had tried to alienate the children to the grandparents, it would have covered that, but this does not. Or if somebody were to move out of state, I guess that would not be covered. But again, the attempt here is to have something that the committee will favor.
Okay. Representative Holcomb?
Thank you, Mr. Chairman. My recollection of the committee was there were two different parties at issue. There were the grandparents that I think you're trying to help, and then there was the mother in the case that was reported. Correct me if I'm wrong, but my reading of this is that this would not impact the case for the mother because her situation is already kind of set in stone, right? Because my recollection was she had moved into her visitation agreement after her son had deceased. Because I have some pause about making her go through litigation again, and I don't think that this would cause her to, correct?
I have Gary Graham, who is a family law attorney. He was with me at first presentation, and he's with me again today, and I'm going to ask him to answer that.
You need to pull that mic over.
Correct. It would not allow the NAMDAR grandparents at this point in time to seek a modification because they acquired the visitation by virtue of their son's death.
Okay.
And so once they acquired the visitation by the virtue of their son's death, under this, then they can't modify.
Okay, so stated even more clearly, it doesn't impact them, but it would give the grandparents that you're trying to help an opportunity to seek redress in the court,
Mine?
correct?
No,
Yes.
the grandparents that brought this to my attention, the retirees from St. Simon's, it would help them.
Okay, understood. Thank you.
All right. I have no other questions. What's the will of the committee? All right. Any further discussion? All those in favor say aye. Aye. Any opposed? All right.
Thank you, Mr. Chairman. Thank you, committee.
All right. Senate Bill 173.
Buddy, we'll do that when I get there.
All right.
I think I have it in here.
I think it's a one pager. I think it.
Oh, is it? Oh, I must be getting it stuck.
it
There
got
we go.
stuck.
Ah, there we go. All right. Senator McLaren, if you would, explain the bill.
Thank you very much, Mr. Chairman. It's great to be back in this room where I've spent so many hours myself and to see friends. I will honor the Vice Chair's prayer for brevity. SB 173 is an attempt to create a mechanism that allows parties to civil litigation to move cases faster on uncontroversial or uncontested motions. This bill does not address contested motions where the parties are disagreeing about what should happen and the court has to make a ruling between the two parties. So, 99% of judges move cases quickly and do their best to follow deadlines on time and to get cases moving, but occasionally litigants will find that motions will just sit for a while, months, sometimes even years. And these horror stories are less rare than they should be. The courts have worked with me on this. I'm very grateful to them for clarifying that their big issue is that they don't often get notice that a motion is filed. So in our courts, unlike the federal courts, the clerk's offices are not always under the control, in fact I think rarely, of the superior courts or the state courts. So a motion might be filed with the clerk's office, but because that clerk is separately elected, the clerk may not always convey knowledge of that motion to the court that is responsible for ruling on it. And I've even heard a horror story about a court that had to send an open records request to a clerk's office just to find out what cases the judge was staffed to. So we have a coordination problem with some of our courts. This bill does a couple things, and I went ahead and put a substitute in front of you today, unlike the sort of bare bones bill that passed the Senate, because I want to address the court's concern. The superior courts have been great to work with on this, and they gave me a roadmap for how we might make their problem solvable.
So our LC is 559006S.
Correct. Thanks, Mr. Chair, for clarifying.
Right.
And very quickly, subsection A, line 15, just says Superior Court judges and state court judges is what this applies to, creates the uncontested motion, notice of uncontested motion mechanism. So within 90 days, if a motion sits for 90 days and there's no ruling and nobody objects, a party can file what's called a notice of uncontested motion. That starts a week-long clock under subsection B, in which the judge can rule. Now, nothing in this code section prevents a judge from denying a motion without prejudice if they want more time. And the sub that I just created in subsection C creates a tolling mechanism if a hearing is scheduled. So the court specifically said to me, we'd like to be able to schedule a hearing if we can, even if it's uncontested. And you might think in a family case, custody determination, something where the best interest of the child is the standard, maybe the parties agree about something, but the judge might have a different view. So that's totally valid. And what a hearing would do is toll the operation. So it would hit a pause button on the 90-day clock and the week-long clock for as long as a hearing is scheduled. Now, subsection D is just what I'm calling the tiniest tickle of accountability. If this mechanism is used twice to automatically deem a motion granted by operation of law, then the chief judge of the circuit has to do a docket management review of whoever the judge is in question. And that's just to say, I mean, this is very awkward. It's very awkward for lawyers to talk about judges who don't rule in a timely fashion. Lawyer legislators are kind of the only people in the state who get to have this conversation. I think the judges have been very understanding about that. So again, want to express my gratitude to them for that. And then subsection E, just, this is not the preclusive or exclusive remedy for docket management. Now, what we've done in the sub, lines 31 through 39, is add a new code section that solves the court's coordination problem. So the subsection A basically just says that attorneys have to do what many attorneys already do as a matter of best practice. When you file a motion, you email that motion to the court so that they have notice that it's been filed. And usually that's to a staff attorney or some other agent of the court. Subsection B cleans up the problem that some courts somewhere don't always let you email them directly. So we're just going to make a rule through this bill, if you allow it, that would mandate that statewide courts present an opportunity to litigants to email the court directly when they're filing motions. Now, the one thing I want to bring the committee's attention to, because this is, fast-moving, late session, the notice itself of uncontested motion, among other notices, those notices should be included alongside motions as the things that need to get served on the court. So I would welcome a friendly amendment from the committee that basically anywhere from lines 31 to 39 you see the word motion, that also says or notice, or notice, or notices, because I think that would accomplish the full purpose. And if that change is made, subject to any other changes the committee would like to make, I think this thing is ready to rock, to use a formal terminology about it. I think this is a small bite. It is not the end-all be-all solution to backlog of civil cases, but I think it's a step in the right direction. It would give a lot of litigants more power over the movement of their case. Thank you, Mr. Chairman. I'd be happy to answer questions.
Okay, we've got a few. Representative Hong, is that you?
Yes, it is.
All right.
Sorry. Thank you. Thank you, Chairman. Thank you, Senator. I like the bill. How many times have we sat around and waited for motions and whatnot to be ruled, and a case is sat around? So thank you for the bill. I just want a little bit of clarification just based on your testimony or your explanation of the bill. Are we talking about consent motions, or are we just talking about motions in general where there has not been an objection filed?
That's a good question. It covers any motion where there's not an objection. So it's not necessarily a motion that every party or intervener has signed. It's a motion that if one party makes it and no other party responds. And the other thing is, under the Civil Practice Act, it's the rule that you have 30 days to respond to general motions. So I'm giving them 3 months, 90 days would be under the bill where nobody has responded. So in theory, you could be in default on a motion 60 days in, still file an objection, and that would take you out of this bill because no objection has been filed, or an objection has been filed rather, within the 90-day period.
Okay. And then on the second section, as far as giving a copy, there are jurisdictions, I kind of didn't understand that part, where there are jurisdictions where we don't have judges' email or contact information readily available. Sometimes you call, nobody answers. So what was that part that you were saying
Sure.
that we're making?
I'm going to quickly read lines 36 through 39. Each judge of a court in which the provisions of this chapter of the Civil Practice Act apply shall, by the issuance of a standing order or any other manner, provide instructions on how parties are to any case before such judge can provide copies of filed motions to such judge pursuant to the provisions of subsection A. So it basically is a new requirement that if there are circuits who do not make any contact information available by design, those circuits will have to provide at least an email address where motions can be served, because then that takes away the explanation, we didn't even know the motion was filed. There has to be some basic requirement that we know the court has received the motion.
Okay, thank you.
Of course.
Okay. Representative Kelly. Okay, sorry.
Yes. Thank you, Mr. Chairman. I do have some questions. So, I'm looking at line 25, section D, and it says it's requiring the chief judge of the jurisdiction to shall conduct a review of the docket management techniques and procedures. And then they shall issue a report of his or her findings. And so the question becomes, I have three. One, what if they are the chief judge?
I've gotten this question before, and Representative, I would submit to you without turning too hard into the comedy of this, that would make the bill more effective.
Okay. The second question that I have for you is, where do they file these reports? In their drawer next to their desk, or is this somewhere they're actually going to have the public?
I would leave that to the discretion of the court. Again, without using too harsh an analogy, I think when students are instructed to write on a blackboard a statement 10 times, it's not for public consumption.
Okay. And when do they have to file these reports? That'd be my last question. I'm trying to understand if these judges are not acting. I'm not a lawyer, so I'll never be in front of one of these judges. So I quite frankly don't care. When do they have to file the report? Is it within 90 days, 30 days, 60 days?
Again, no specific requirements, and that's why the noun I've used is tickle of accountability. This is not a serious threat, and I think it would be inappropriate, candidly, for the legislative branch to put too severe a sanction on this type of thing. I think what we want to emphasize with the bill is that it should not be standard practice to allow these motions to be deemed granted by operation of law. And, for example, the federal courts, you can't remove a federal judge unless they're impeached, right? Or they step down. And but the 6-month list is something that people talk about the federal courts as being a source of, reputational injury. If you have motions that linger too long on a list so that people know that you're not moving cases as quickly as other judges, those social network effects do matter to judges. And so, like I said, this is really just designed to be an opportunity for reflection by courts if they're using this mechanism too often.
And I guess that's good. I mean, that is something that everybody's kind of agreed. You said this passed the Senate, right?
It did on I think 49-5. I felt pretty good about that.
Okay. Thank you, Senator.
All right.
Thank you, Chairman.
Vice Chair Reeves.
Senator McLaurin, I heard from a chief judge kind of late and didn't get a chance to talk through these ideas with you. One thing they pointed out on criminal cases, a lot of times there are boilerplate motions that prosecution or defense files, and they get responded to closer to trial. And the judge asked, for this new bill as the first step, could we apply this to civil motions? And then on civil motions, sometimes, State Farm or somebody will file their motions in limine well prior to trial, and nobody gets around to looking at them or considering them to trial. So the idea, I think this is aimed at civil practice for the most part, but pretrial civil motions, it looks like line 16, properly served pretrial civil motion would be an idea. I know with summary judgment, there are a lot of cases out there saying you can't get a summary judgment by default, and there's, a lot of case law on that. So that's something maybe to take up at another day if this, impacts that. Also, on subsection D, this question that Representative Momtahan asked about the chief judge, the chief judge, one chief judge pointed out to me, at least in their jurisdiction, the chief judge doesn't have like disciplinary authority or any sort of, she didn't think she had this authority over her fellow judges. It's mainly an administrative role. And they handle things other than case management. Shall conduct a review of the docket management and issue a report. Those are some things, at least one chief judge had a concern about in terms of the jurisdictional relationship and otherwise with the fellow judges. Are they going to have the authority to do this? And also, does that change the relationship between a chief judge and the other judges too much? And so I guess my questions would be, on line 16, would pretrial civil motion be all right? And then on D, is that something, can we implement this without that and see how that works and come back later with that if that doesn't work?
In order, number one, I do think it doesn't apply to criminal cases, right? It's just the Civil Practice Act by the terms of the bill. Okay. Two, I would certainly welcome the pretrial amendment. So I believe the Vice Chairman's saying on line 16 before the word motion, the word pretrial. So that would be a very welcome amendment. Also, as far as the tickle of accountability, I'm happy if this committee takes it out. This was just, for me, a way of trying to signal the what I wanted to come from this bill. I think you could defend the requirement as an administrative task. I mean, look, when you're the in charge of planning a committee or planning a party, or you're the person that the administrative duties fall on, you have to nag people sometimes. And so I wouldn't see that necessarily as disciplinary as much as an administrative response. But if the will of the committee in its flurry of amendments is to take lines 25 through 28 out and renumber accordingly, I would welcome that. That's fine.
What about on D, instead of taking it out, have may rather than shall?
Open to that as well. This is your party, Mr. Vice Chairman, and I'm just honored to be here.
I don't know that it is, but thank you.
Thank you.
All right, I guess it's Representative Oliver.
Thank you, Mr. Chair. I'm going to vote for this. The delay of cases cost clients so much money, and this is an essential change. We have several times at this table talked about giving priorities to certain kind of cases, and the result of that is more delay for other kind of cases. So I'm very supportive of this. Justice Boggs' expenditure of ARPA money for a consistent management system is going to solve some problems for us, and I'm looking forward to that. The courts are very inconsistent as to whether they'll accept email, accept letters, accept phone calls, and that's a frustration. So we've got solutions on the way. I think this bill is a good solution. And it signals to Judge Boggs some things that need to be a part of the communication with the court and case management things. I support changing shall to may or eliminating lines 25 to 30. The judges have different philosophies about these reports. They do or don't do them. I think this would give them the authority to do it, but eliminating those lines or putting in a may is probably a better idea.
Just on line 36.
27.
25 to 30.
Document review.
Shall
Yeah.
Or shall issue a report. That's where the may is. Okay. Representative Jones, is that you? Oops.
Thank you. I want to stick with 25 through 28. I'm actually a big fan of your, what did you call it, a tickle? We need more accountability. I'm one of the few people on this committee that pays $900, $1,000, $1,100 an hour constantly to attorneys, and to have things delayed, and frankly, to have 2 or more cases where you just didn't do what you were supposed to do, since you're, quote, treating it like it's a blackboard exercise and you're not publicizing it, having that judge get a little bit of, I'll say, McLovin from the chief judge, I don't think it's a bad thing. The question I have is on 26, line 26. Is there a reason you didn't bracket the 2 or more cases? So for, I'll just give you an extreme example. Is it 2 or more cases in 10 years or 2 or more cases in 1 year? Again, I think if we're going to keep 25 through 28, which I'm not sure if the committee's going to do that, but if I'm in favor of it, I think we should bracket a timeline there, just because, you know, over 10 years, I'm not quite as cranky about it as if they did it over 1 year, let's say. So I think that's something to consider for the committee. Just for the record, I like shall better than may, because there needs to be accountability. My second question is, again, as the payer of legal fees, and watching all the delay tactics that everyone does and just literally launches up my bill. Is there a reason? I've learned a lot about the Civil Procedure Code and the process that's taken. You talked about the 30 days that they have to reply. I've seen so many excuses to delay that 30 days. I actually, they should go on Comedy Central. But at the end of the day, I understand why you wanted to broaden it so much so that you are at least appearing to be fair. Is there any objection to making it 60 days? And the reason why is, at some point, we just need to move these things along. And double versus triple, I still would like it to be 31 days, to be completely frank with you. But is 60 something that the author would consider and that the committee would consider?
First answer your question is that I haven't thought about bracketing it. If you think it's appropriate to, if the provision survives, obviously open to that. And I will just say, as somebody who has billed people like you for your time, 0.2, 0.3 hours just to file an extension of time adds up on its own and isn't even merits work on the case. It's hundreds of dollars. And so I completely agree with the client concern you have there. As far as 60 days, again, I leave that to the committee. I'm just happy that this idea is getting as much attention as it is. So I would just defer to your process.
Thank you.
Yeah.
All right, and Representative Holcomb.
Thank you, Mr. Chairman. I agree with Chairman Jones' comments generally, and just want to reinforce that I also agree with you, Senator McLaurin, that this is only for the Civil Practice Act, so the criminal issues aren't at issue. I want to ask a couple of questions. One is on line 21. This is very technical, but I'm wondering if we should add a comma after granted. If your intent is to make it granted just after the lapse of the time and not waiting for the judge to actually issue the order, because these judges may be slow to issue orders.
I agree with that, and I've heard that concern from a member of the committee that the last part "and such judge" to the end of the sentence might weaken the by operation of law language. It's worth noting, I mean, SB 68, huge overhaul, included a modification of the Civil Practice Act that aligned us more with the federal rule, which is that all discovery is stayed on the filing of a motion to dismiss, and there was some discussion about the follow-up rulings that a court would have to do. And so I think, and kind of to Chairman Jones's point also, my goal here is just to make sure that the court always has a plan, that there's always some attention being paid. And so as long as there's something that's keeping focus on moving the case, I don't care exactly what that mechanism looks like, which is why I think the tolling for a hearing is fully appropriate. But I agree with you, a comma after granted, we'll add it to, is that, I think, Amendment 6 or something at this point, so we'd fully support that.
And that makes it clear that your intention is on day 8. This means that the motion has in fact taken effect, correct?
Correct. That's right.
And then my second question is, and I guess it will be contingent on what happens with lines 25 through 28, is in DeKalb, for example, we have a chief judge of the magistrate courts, the state courts, and the superior courts. So how would you interpret jurisdiction in that circumstance? Would it be jurisdiction for the circuit or jurisdiction for each respective court?
I think it's each respective court proper. I mean, let me look at the language. You're talking about subsection D.
Yeah, line 26.
I see the jurisdiction of issue. I mean, maybe even just the court at issue would clear that up.
Okay. Thank you.
Yeah.
All right, Vice Chair Reeves.
I have a motion with amendments at the proper time.
Let's go ahead and do it.
All right. I move to pass.
All right.
And I have 5 amendments. If that doesn't clear it up, I'd be glad to add a 6th if any of the members will bring that to my attention. But on line 16, between the words served and motion, I move to add pretrial as amendment number 1. On amendment number 2, on line 17, I move to amend to strike 90 and put 60. On lines 23 to 25, on 25 to 28, subsection D, the third amendment would be to strike shall in both places and put in may. The fourth amendment would be on line 26, in 2 or more cases before such judge, add within 2 years to give a time frame. The fifth amendment would be on line 21, deemed granted and entered, and then strike, and such judge shall enter an order granting such motion. And then along with that amendment, that fifth amendment, on line 25, after granted, put granted and entered. That way there will not need to be a separate document from this delinquent judge. Those are 5. There may have been one more.
Or notice on line 34.
Line 34, add notice, would be the 6th amendment.
After motion, or notice, and then line 38, or notice.
If I may, so everywhere it occurs would be, I think, 32, 33, 34, and a plural one on 38.
That is my 6th motion for an amendment.
I'll second Mr. Chairman, ask we take them all at once.
All right.
I have one more.
To change on line 26, jurisdiction to court of issue, to make that clear, or court at issue, to make that clear.
And I second Representative Holcomb, or add that in as the 7th amendment for the package.
Yeah, I didn't get that. What was that again?
Court at issue replacing jurisdiction on line 26.
What was the first part of your amendment?
Oh, you're right.
On line 16, between served and motion, have pretrial.
All right, everybody clear on the motions? Or the amendments, excuse me. All right, all those in favor say aye. Aye. Any opposed? All right. Well, first of all, did I get a motion? I did? Okay. I get lost in this. All right. Any further discussion? All those in favor of the bill say aye. Aye. Any opposed? All right, bill passes.
Thanks very much, Mr. Chairman.
All right. Senate Bill 36. Okay.
Mr. Chairman, may I be heard?
Yes.
All right. Mr. Chairman, and 36 is on the table. In the last meeting, the Georgia Municipal Association had requested an amendment. They drafted the amendment. They have 537 cities. Last year they had 536. Of course, we all know Mulberry is the latest of their 537. I know there were K through 12 school representatives, county representatives in here. This bill would apply to state agencies, to K through 12 schools, every state and local government. So that amendment, you know, I felt like, and I think the committee felt like, was warranted. But since the meeting last week, the sponsor and the supporters of the bill have very, you know, vehemently and zealously requested for him to attempt to move the bill without that amendment or any others. So I, Mr. Chairman, request for the amendment requested by GMA to be removed, withdrawn. To the extent we need an amendment to be able to do that, I would ask for that amendment to be granted, but I do withdraw the GMA amendment. You know, Georgia law has an anti-litem notice, but Texas has one that is 60 days. So that was the source of the amendment. They're here, but I withdraw that and give the sponsor an opportunity to try what he's requested.
Okay. All right, hang on. I got some folks that, all right, 13, Tyler Paul. All right. And
I'll just ask you a couple questions. We
What?
heard extensive debate, and I think it's time to vote.
all right. Right. Representative Oliver.
Forgive me, I need to catch up here. You're asking that we will remove the amendment we passed for any litem notice.
Right.
What are you asking we vote on?
They'll remove it.
Just that? Okay.
Okay. All right. Representative Evans.
Chairman. I just want to get some clarity on the procedure because we have already, a motion to pass the bill as amended failed. And the last thing we did before we left and adjourned was move to reconsider. So we're already 2 actions past the amendment. And I don't understand any rule of procedure of either this committee, the House, or Robert's rules that allows you to go back 3 steps.
Well, we have reconsidered, and now we're going to vote on a motion to withdraw that amendment and then move forward from there.
I think we would have, with respect, I think we would have to deal with the motion for reconsideration, which also was out of order because it was made by a member of the losing. A motion to reconsider is only proper if made by a member who was on the prevailing side of a vote. And I recall it being made by Representative Montahan, who had voted with the side that lost on the motion to pass.
All I recall is that the motion was made and it was voted on, and so we've reconsidered, and this is what we're doing at this point.
Yes, sir, Mr. Chairman. I would just say that if someone wanted to challenge the ruling of the chair, it would have been proper to do it in the meeting, not today.
Well, we're not going, it sounds like we're going 3 steps back, though. I'm just trying to get clarity on what we're actually voting on, and then I may have further questions.
We're voting to remove the amendment that was adopted by this committee.
Okay. And, Mr. Chairman, I would, if that's the ruling of the chair that you're going to allow that motion, I would challenge it as improper because under Robert's rules, you can't just keep amending the same section like a volleyball. If the motion to amend just undoes exactly what you just did, it is improper.
Okay. Well, I'll overrule that. So,
I move to challenge the ruling of the chair.
okay. Then where do we go from here? You want to go talk to the Speaker's office?
No, we would just make a vote. We would just have a vote, Mr. Chairman.
All right.
The motion being to overrule the ruling of the chair.
Okay.
That's the motion.
So a vote here would be, a yes vote here would be against our chairman, is that correct?
Yes.
Okay, thank
Against
you.
the chairman's ruling, not the chairman as a person, who I respect very much.
Okay. Tyler Paul?
Mr. Chairman, I want to just note, Mason's Manual of Legislative Procedure is what governs here, not Robert's Rules of Order.
And where is that?
We can have the vote. I think we're here for
I got a copy of it. I can let the gentlelady borrow.
Well, and also the reference to how it applies here, but understood.
All right, so what's our position then? We're gonna vote on that?
I think we're going to vote on her motion to overrule the chair.
Yeah.
I guess we're voting on the motion to challenge you, Mr. Chairman.
Okay, all right, all those in favor of the motion made by Representative Evans, say aye.
Aye.
Any opposed?
No.
The noes have it. All right, so-
Division.
I'm sorry?
Division. Just showing of hands.
All right. All right, all those in favor, raise your hand. Yeah, you're voting to overrule me. All right, 1, 2, 3, 4, 5. All right, all those opposed? 10. Okay. Motion fails. All right. Back again. Nope, you're done? Okay. Nothing? All right.
Can I have clarity, point of information, Mr. Chairman, on, are we voting on, which LC number are we working off of? Because I've got a substitute in my folder, and I only have a copy of the original bill because I brought it.
Is this the one with his amendment on it? Okay. Working off of 481603 ERS.
1603 ERS. Well, does that represent what we passed, or what failed to pass as amended?
Yes.
Okay. Yeah.
Okay. Representative Kelly?
So the amendment we're about to vote on, the withdrawal of the amendment we're about to vote on, I just want to make clear myself. So that would be basically striking lines 58 through 67. That's what your amendment does in practice, Chairman Reeves?
Yes, it does.
All right, thank you.
Could I ask one more question, Mr. Chairman, just because I'm looking at the original bill, and there was, I don't know if anyone else has it, I just happen to have it because I brought it, but lines 59 through 67 of the original bill said nothing in this chapter shall be construed to affect, interpret, or in any way address that portion of the First Amendment of the Constitution of the United States, and it goes on. That's not in the LC number that you read that we're voting to take an amendment out of right now, and I don't remember us taking it out in the original committee meeting.
I'll ask the author if he might be able to clarify what's going on.
Yeah, Mr. Chairman, I did not see the sub until this morning. It would appear there would be different postures for the committee. If the committee were to simply withdraw the amendment offered as opposed to the committee substitute, the amendment would come off and it would be restored back to the version that passed the Senate, that was candidly drafted in concert with our governor, that had the language the lady spoke
What
to.
LC do you have right there?
LC 442920 is what passed the Senate, and if it were the pleasure of the committee to simply withdraw the amendment, not dealing with the substitute, but simply withdraw the amendment, we would be back the committee would be back in the posture to act on the underlying bill as passed the Senate.
Right.
That might be the cleaner motion procedurally in this.
All right. Yeah, let's pass those out.
And, Mr. Chair, if I may be heard,
You're blind.
online, Senate Bill 36, the ER number that is online for everybody to see is LC 442920 ER, which is the version that Senator Setzler just mentioned. The anti-litem notice was the only amendment that passed last week. Therefore, this as-passed Senate version of that LC number would be what we would proceed under if the amendment is withdrawn or voted down.
So because my understanding, Mr. Chairman, was we're not operating in the context of the substitute. It was simply withdrawing an amendment off of the original version. That was my,
That's
and
my
again,
understanding.
if it pleases the committee, that would be the preference of the author to simply restore back the language as passed the Senate.
Well, point of clarification, can we have an amendment withdrawn when we've already voted on the amendment and taken a vote on the underlying bill?
I believe we can.
And that's what we just voted on. That was a challenge, and that's what we just voted on. And now we should call the question on the amendment, Mr. Chairman.
Okay.
We've debated it. We've challenged the chair. We've moved forward. Then we ought to vote.
All right.
Correct.
And the
I
amendment
call-
is what?
To
For
withdraw
clarity.
the amendment.
I call the question. All those in favor say aye.
Aye.
Any opposed?
No.
All right. You wish to have a hand vote?
Division.
All right. All those in favor, raise your hand.
Yes.
I got 11. All those opposed? All right. Motion passes.
Call the question on the original bill, Mr. Chairman.
All right.
For clarification, are we back to voting right now when you say the original bill?
LC 442920ER.
Okay.
Thank you.
All right. All those in favor say aye.
Aye.
Any opposed?
No. Division.
All right. All those in favor say aye, or not say aye, but raise your hand. No, I got more than that. 1, 2, 3, 4, 5, 6. Okay, you're correct. 9. All those opposed? 6. Okay. All right, motion passes.
Move to adjourn, Mr. Chairman.
All right, we're adjourned.
Thank you, Mr. Chairman.